All right, it's 9 o'clock. We're going to try to get started as soon as we can, so please find your seat and we can get started. All right, the hearing will now come to order. Today is July 19th, 2017. The time is 9:02 a.m. and we were assembled at the Doña County Government Center in Las Cruces, New Mexico. My name is Dylan Lang. I'm an Assistant Attorney General, and I'll be acting as the presiding officer for today's public comment rule hearing. The purpose of this hearing is for the New Mexico Office of the Secretary of State to receive public comment, views, and testimony on its proposed rule to be codified as 1.10.13 NMAC. The Secretary of State welcomes anyone present at this hearing, whether in person or remotely.
Good morning, ladies and gentlemen. I just want to say a quick introduction and welcome. I'm Maggie Toulouse-Oliver. I'm the Secretary of State, and I wish there were a few more folks here, but as I've said hello to each of you individually, I just want to say hello again. Thank you very much for being here and for participating in this important process, and my staff and I look very much forward to hearing from you all this morning. Thank you.
This hearing will be conducted pursuant and in accordance with NMSA 1978, Section 1-19-26.2, which authorizes the Secretary of State to adopt and promulgate rules and regulations to implement provisions of the Campaign Reporting Act, the APA, NMSA Chapter 12, Article 8, and the State Rules Act, Chapter 14, Article 4. Public notice for this hearing was advertised in the New Mexico Register on June 13, 2017, and in the Albuquerque Journal, the Santa Fe New Mexican, and the Las Cruces Sun News on June 13, 2017. Copies of the proposed rules have been available at the Secretary of State's office since notices were published. Copies of the proposed rules were also published at the Secretary of State's website and are available to anyone in attendance today in the back of the room. Copies of the proposed rule were also available upon request as of June 13th, 2017 through the Secretary of State's office. This hearing is also being live streamed on the Secretary of State's website at http://www.sos.state.nm.us. May I remind everyone to sign the attendance sheet that will later be entered as an exhibit into the record of this hearing. Let the record show that staff from the Secretary of State's office is present: the Secretary of State Maggie Toulouse-Oliver, Deputy Secretary of State John Blair, Elections Director and Chief Information Officer Carrie Fresquez, and Deputy Election Director Mandy Vigil. This is a formal proceeding, and a court reporter has been designated to transcribe the proceedings. The transcript of this hearing will become part of the rule hearing record. Therefore, persons recognized to testify or offer comment are asked to identify yourself each time you address the presiding officer and speak loudly and clearly so the hearing officer, the court reporter may hear you and be able to pick up your comments. The hearing will be conducted in the following manner. I will open the hearing for testimony and comments from the audience. If you have indicated that you would like to testify, you should have signed your name on the corresponding attendance sheet. So if you'd like to speak on definitions, please make sure that you've signed up on that attendance sheet. We'll proceed in numerical sequence through each part of the proposed rule. I will call individuals to testify in the order they have signed up. After public comment is given on specific sections of the rule, I will call for general comment. If you would like to give general comment about the proposed rule, please save your comment until the general comment period. Speakers will address only one part of the rule at a time until the general comment period. Please limit your testimony only to the part of the rule that we are receiving testimony on. The SOS does not follow the rules of evidence, but shall, in the interest of efficiency, reserve the right to limit all exhibits, testimony, and commentary as if deemed irrelevant, redundant, or unduly repetitious. The decision as to whether such exhibits, testimony, or commentary is irrelevant, redundant, or unduly repetitious shall be made by me, the presiding officer. After a person has testified or offered comment, any member of the audience wishing to ask a clarifying question may do so after being recognized by the presiding officer. Each person recognized to speak shall identify him or herself for the record. Questions, though, will be limited to only clarifying questions. This is a public hearing intended to provide the public with an opportunity to voice opinions on the proposed rule. The public hearing is now open, and the Secretary of State's office would like to incorporate by reference all exhibits that we've received from prior to our two public rule hearings, one in Santa Fe and one in Albuquerque. Those include the legal notice published in the New Mexico Register, the legal notice published in the Albuquerque Journal, Santa Fe, New Mexican, Las Cruces Sun News, the proposed rule in its entirety, any written comment we've received at those public hearings, and any and all written comment that our office has received throughout this whole public comment period. We will offer as an exhibit all written comment that we've received in the office not introduced by the close of business at 5 o'clock. That is when up until we are receiving written comments on this rule. After 5 o'clock, we will admit then all documents that we've received as written comment on this rule and will be attached as an exhibit to the final record. Any persons wishing to submit additional written testimony may do so after being recognized by me after their comment or at any time during the process. I'll ask any person who will be testifying or commenting at this hearing to please rise and be sworn in. So if you do intend to give testimony, please stand. And raise your right hand, please. Do you solemnly swear or affirm that the testimony or commentary you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record show that all persons intending to testify or comment at this hearing have sworn or affirmed that his or her testimony and commentary is truthful. I will now open the floor to the audience for testimony and comments on each part of the rule. The audience may ask clarifying questions to each person after providing his or her testimony. To begin, may I see a show of hands of how many people in attendance support the rule and how many people oppose the rule? Thank you. I don't believe anyone has signed up for Section 1, issuing agency. Is there anyone in attendance here who would like to speak on Section 1, issuing agency? Seeing none, we'll move to Part 2, scope. No one has signed up to speak on Part 2, scope. Is there anyone here today in the audience who would like to give testimony on scope? Seeing none, we'll move to Part 3, statutory authority. No one has signed up to speak on Part 3, statutory authority. Is there anyone in the audience who would like to speak on that? Seeing none, Part 4, duration. No one has signed up. Is there a member of the audience who would like to give comment on Part 4? Seeing none, we'll move to Part 5, effective date. No one has signed up. Is there a member of the audience who would now like to give testimony on Part 5? Seeing none, we'll move to Part 6, the objective. No one has signed up to give public comment. Is there a member of the audience who would like to give comment on Part 6? Seeing none, we will move on to Part 7, definitions. Ms. Fresquez.
Thank you, Mr. Lang. Part 7, entitled Definitions. This section defines important terms used in the rule and the Campaign Reporting Act, such as advertisement, ballot measure, coordinated expenditure, independent expenditure, loans, debt, treasurer, and others.
Thank you. First person on the list is Mr. Michael Aguilar. Please come forward.
Good morning. I just have a couple comments based on the some of the language in the proposed rule change. Starting with right at the top on Part A, advertisements. The definition of advertisement is pretty broad and includes terms like print that are very vague and can be interpreted differently based on the person who chooses to interpret these rules. Moving down to communication. Communication by membership organizations to its members. This concept really doesn't define membership or members. This could cause some kind of confusion for many organizations like mine that and groups as to which of their communications should be considered advertisements or not. Going down to Part F, we have coordinated expenditure. So attempting to define coordination in this manner could lead to false accusations and or unattended coordination by like-minded individuals, or brief conversations in which a candidate mentions a need or struggle that is then interpreted by an individual as a suggestion for help. Moving right along to earmarking. Unless a final draft of a given expenditure is provided to a donor, that donor is unable to explicitly agree to earmark their donation for expenditures that could cause their name and address to be subject to public disclosure. Expressly advocate. The nature of this definition for this word is up for interpretation and will be nearly impossible to set a precedent for. M, for independent expenditure. It's unclear if only one of the three parts of item 3 must be evident to be considered an independent expenditure, or if all three parts must be evident. Part C of item 3 in this section will undoubtedly classify the issue-based advocacy work and informational publications of many non-political groups as independent expenditures, thus requiring them to disclose their donors. And that's all I have for you today. Thank you.
Thank you. Next on the list is Vicki Harrison.
Thank you very much, Vicki Harrison, Common Cause, New Mexico. We appreciate the Secretary holding these hearings in 3 places in the state. That's 3 times above and beyond what you have to do, and we do appreciate that. Of course, that means you get to hear from advocates 3 or 4 times. I just want to say on the definitions, there is a lot, I appreciate what the gentleman said before me, but a lot of these definitions have been taken from existing federal law and federal court cases and have been vetted for that. And so I think that particularly for us, M on being able to narrow the definition of independent expenditure is incredibly important because of all the court cases that have struck down pieces of our current Campaign Reporting Act for being incredibly broad. And by narrowing it down and really drilling down on the pieces that those groups who are truly non-major purpose and not doing express advocacy, which has been defined for many, many years, then they will not be caught up in this. What they will be caught up in is when they do jump in and do express advocacy, which means, vote for or vote against, or do any kind of issue advocacy right before an election. Both have been vetted by the courts, not only in the 10th Circuit, but as well as the Supreme Court. And with that, I'm just going to end with something I rarely do, but a little quote from Justice Scalia, who, as we all know, was part of the group that passed Citizens United and said, let's just open the floodgates on money with the assumption that we would know where it came from. And the year before Citizens United, in another case, Scalia said, requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. For my part, I do not look forward to a society which, thanks to the Supreme Court, campaigns anonymously, hidden from public scrutiny, and protected from the accountability of criticism. This does not resemble the home of the brave. Thank you very much.
That is everyone who's signed up for Section 7. Is there anyone from the audience who would like to speak on Section 7? Seeing none, we'll move on to Section 8. No one has signed up for Section 8, Candidate Campaign Committee Registration. Is there a member of the audience who would now like to speak on Section 8? Seeing none, we'll move to Section 9, Withdrawing from Candidacy. No one has signed up for Section 9. Is there a member of the public who would like to speak on Section 9? Seeing none, we'll move to Section 10, Political Committee Registrations. No one has signed up. Is there a member of the public who would like to comment on that section? Seeing none, we'll move to Section 11. Ms. Fresquez.
Section 11 is entitled Reporting of Independent Expenditures. This section clarifies how entities shall disclose independent expenditures with the Secretary of State, including when and how to disclose the source of funds used for the advertisement, as well as the dollar thresholds that trigger the required disclosure. This section further clarifies that candidates are not required to report independent expenditures.
Thank you. First on the list is Ms. Harrison.
Thank you again. Section 11 is what I previously mentioned to, and narrows the reporting for those who do not have a major purpose of playing in elections. And so these are for people who every now and then do a political advertisement, which they can absolutely do as a C4. And so every now and then they throw out an ad or do a mailer or do a door hanger, and then this gives them a mechanism. Again, court cases have said these are great thresholds, good language, and but it's not their primary purpose. So for example, Common Cause New Mexico, we don't play in elections, but if there were a ballot measure that came up around one of our issues, public financing, ethics, disclosure, good voter bills, then we would do that and we would fall in this. And if we spent this, so this is really narrowing, because again, our current Campaign Reporting Act says anybody who spends $500 to influence an election in a year, and that's just, the courts obviously have said that's insane. You can't require that much. So we really appreciate the Secretary working to really draw down and say, you know, again, these are people who've either earmarked their donations for the ads or they reach a certain threshold of $5,000. Thank you very much.
Mr. Aguilar, you're next.
Good morning, and I just wanted to clarify, last time I came up here, I didn't introduce myself. My name is Michael Aguilar. I'm the Executive Director of the Southern New Mexico Business Alliance. So moving forward, we have Section 11. We go down to Part C. In a 12-month period to donate up to $200, that's not really causing the disclosure of people contributing quote-unquote dark money, but it's really the average citizens who have donated their hard-earned money to a particular cause that may have produced incidentally political independent expenditures, according to the vague definitions listed elsewhere in this rule. These ordinary citizens should not be subject to their name and address being made public in association with any given organization. A series of small donations equaling $200 within a 12-month period will not buy an election. Additionally, the process of recording every small donation by every individual for every 12-month period, rather than a calendar year or election cycle, is burdensome to many small organizations like mine by consuming time and/or money for staff or volunteers.
There are no other names on the sign-in sheet. Is there a member of the public who would like to speak on Section 11 at this time? Seeing none, we'll move to Section 12. No one has signed up for Section 12, General Reporting Rules. Any member of the public would like to speak on this? Seeing none, we'll move to Part 13, No Activity. No one has signed up. Is there a member of the public here today that would like to speak on Section 13? Seeing none, we'll move to Section 14, Supplemental Reports. No one has signed up to speak on supplemental reports? Is there a member of the public who would like to speak on this section? Seeing none, we'll move to section 15, late filing of reports. No one has signed up to speak. Is there a member of the public who would like to speak on this section now? Seeing none, we'll move to part 16, loans. No one has signed up to speak on part 16, loans. Is there a member of the public who would now like to speak on this? Seeing none, we'll move to part 17, campaign debts. No one has signed up to speak on campaign debts. Is there a member of the public who would like to speak on this section now? Seeing none, we'll move to part 18, in-kind contributions. No one has signed up for in-kind contributions. Is there a member of the public here today who would like to speak on this section? Seeing none, we'll move to part 19, volunteers. No one has signed up for this section. Is there a member of the public who would like to speak on volunteers now? Seeing none, we'll move to part 20, contributions. No one has signed up to speak on section 20, contributions. Is there a member of the public who would like to speak on this section? Seeing none, we'll move to part 21, candidate designations of contributions over the limit. No one has signed up to speak on part 21. Is there a member of the public who would now like to speak on part 21? Seeing none, we'll move to part 22, excessive or prohibited contributions. No one has signed up to speak on this specific section. Is there a member who would now like to speak on this section? Seeing none, we'll move to part 23, date contributions made versus date of receipt. No one has signed up to give comment on this section. Is there a member of the public who would now like to give comment on this section? Seeing none, we'll move to part 24, earmarking. No one has signed up to give testimony on earmarking. Is there a member of the public who is in attendance now who would like to give comment on earmarking? Seeing none, we'll move to part 25, candidate expenditures. No one has signed up. Is there a member of the public who would like to give comment on candidate expenditures? Seeing none, we'll move to part 26, charitable donations. No one has signed up to give testimony on charitable donations. Is there a member of the public who would now like to give testimony on this section? Seeing none, we'll move to part 27, primary and general election cycles for purposes of contribution limits. No one has signed up to give testimony on this section. Is there a member of the public who would now like to give testimony on this section? Seeing none, we'll move to part 28, coordinated expenditures. No one has signed up to give testimony on coordinated expenditures. Is there a member of the public who would now like to give testimony on section 28, coordinated expenditures? Seeing none, we'll move to section 29, records retention. No one has signed up to give comment on this section. Is there a member of the public here today who would now like to give comment on this section? Seeing none, we'll move to part 30, random report section and report review process. No one has signed up to give testimony on part 30. Is there a member of the public who would now like to give testimony? Seeing none, we'll move to part 31, disclaimer notices on advertisements. No one has signed up to give testimony on this section. Is there a member of the public who would like to give testimony on this section? Seeing none, that concludes our specific testimony we're receiving on specific sections of the rule. I'll now invite anyone who would like to give general comments about the rule to come forward. Please identify yourself. Thank you. Whoever would like to come first. Sir, please, thank you.
My name is Lynn Ellens. I'm the Chief Deputy County Clerk here in Doña County. I just want to make one short remark. There's been a lot of press reporting that opponents of the rule believe that disclosure of a person's identity is an invasion of privacy and a violation of free speech. As a former candidate, I'm required to report a contribution of any amount. And the person who contributes to my campaign, or used to contribute, is also subject to have that name publicly disclosed. I see no difference between that and contributing to an organization who will then disclose the name of the contributor. So if there's a violation of privacy, It's been all over the place for years, but I don't believe there is. Thank you.
Next, general comment. Ms. Harrison.
No, I was making sure that there wasn't anybody else, so I didn't jump in. As a general comment, I just want to say that, again, since the Campaign Reporting Act is so broad, requiring all of this reporting from anybody spending over $500, there is not a single requirement in these rules that has not already been encompassed in that sweeping mandate. So if you think about it, these rules are only narrowing what the statute already says. And the rules are trying to describe a way that the various courts have done this limited disclosure around broad mandates. So with these numerous court cases leaving the Secretary of State's hands basically tied and basically having to look at every single complaint in the upcoming election season, I call it a session, they're all sessions, you would have to look at them one by one, piecemeal. To me, that's the true stomping of democracy. That's the true danger to free speech, is because the independent groups won't know what the rules are. They'll just have to throw something out and see how the office deals with it, and the office will go to these same court cases, because they're the court cases that we have right now in this circuit and in this country, and come up with the same thing. So by publishing these rules, you're leveling the playing field. And again, only requiring those people who specifically said, use my money for politics, use my money to jump in and take somebody out or put somebody in. Well, we all know it's to take somebody out. I mean, negative ads are 97% of these ads. And we just need to have the fair rules of the game. And that is true free speech. That is true democracy. And again, we applaud and commend the Secretary of State's office, and we don't say this enough, but obviously the AG's office as her helpful enforcing arm in this process, and the staff, to not only have these hearings, but to have 3 instead of 1, and to come to Las Cruces and not just be in Santa Fe. Thank you very much.
Any other members who would like to give general comment, please come forward. Well, Mr. Aguilar will come, and then, okay.
My name is Mary Burton Risley. I'm a 4th-generation New Mexican, now living in Cliff near Silver City. I didn't intend to speak. I sent in my comment. I want to thank the Secretary very much. I'm in favor of all forms of transparency, but I have a question. It seems like there's no other country where people start campaigning years in advance, and that they're allowed to spend money on ads and collect donations and everything. And I don't know if the Secretary of State's rules could include any kind of time limiting of that. And of course, I think what would be the healthiest for our government is public financing, and I realize that is not in your purview, but thank you so much for your work.
My name is Patrick Lamb. I'm a registered voter here in Las Cruces. I have no other affiliation with any organization, but I do want to thank the Secretary of State for holding these meetings in Las Cruces. Sometimes we get forgotten down here in the southern part of the state, and commend you for taking this step of having this campaign reporting issue looked at. My wife and I sort of got interested in this issue when she read the book Dark Money earlier this year. And since then, I've been concerned about things like, and I'm not sure that this particular proposed rule would affect it, but the amount of money that was put into the campaign in Santa Fe on the soda tax was really quite astonishing. And it's an issue that I think we need to look at, where campaigns can be influenced by large amounts of money, even coming from out of state. The other thing I'd say was several years ago, I entertained the possibility of running for a position in the state legislature. And when I talked to the person who was then holding the seat, who was moving on to another position, I asked her how much it would cost to run for that office. And she told me, and this is a state representative office, about $40,000. And that occurred to me that that was an incredible amount of money for a position that you'd have to spend that amount for maybe every 2 years. And I think it keeps a lot of people out of the possibility that they'd run for a public office, which I think is something we all ought to consider. And maybe putting some sort of limitations would allow more people to become involved in office. I do completely understand the First Amendment and the right of free speech, but I think it's time we look in general at all aspects of campaign finance so that it's a little bit more open, transparent, and makes the thing easier for us all to participate in. Thank you.
Good morning. Once again, my name is Mike Aguilar. I represent the Southern New Mexico Business Alliance. The Southern New Mexico Business Alliance is a local 501c4 nonprofit organization dedicated to fostering a healthy balance between local government and business. SNMBA, like other 501c4 organizations, is not required to disclose our donors. And let me tell you why that's a good thing. Before SNMBA was created, business owners were quite literally afraid to speak out regarding issues that they believed in. And I'll tell you why. In the past, business owners who were harshly targeted by, activists who showed up to their businesses, created boycotts, stood outside their doors, completely within their legal rights. But could you imagine owning a business and having these people chase your customers away, all because you decided to speak up about an issue that you believed in? And that's what was happening down here in Las Cruces. In fact, it became so bad that some of these activists began showing up at these business owners' homes. And that's all because their information, their private information, was published on a government list that was readily available to anybody who decided to look it up. That created a threat to their families. It got so bad that one personal friend of mine, also a business owner, was forced to hire private security to keep their home safe. They had kids, a wife and kids, and when people start showing up to your home to speak their mind about an issue that they believe in, it gets scary. So if you get your way, Madam Secretary, and are successful in creating law by circumventing the state legislature and our governor, you'll be putting those members of our community back at risk. People in our community will have to choose between being attacked for their beliefs or remaining silent to protect their families. It seems to me that we should be leaving legislating to the legislature. Thank you.
Good morning, Madam Secretary and staff. Thank you for the opportunity to speak today. My name is Doug Nickel of Take Back Our Republic. We are a conservative nonprofit engaged in research, education, and advocacy on common sense campaign finance reforms. We do so at the local, state, and federal level because we believe that campaign finance reform is the first and most effective step toward providing increased access and engagement in our political system for our fellow citizens. So first of all, I'd also like to thank my fellow citizens for showing up here today. This is a participation sport, and unfortunately the turnout today is reflective of the overall engagement in substantive issues. We have plenty of people involved in the visceral and emotional issues of the day, but unfortunately those issues will never be resolved until we increase the regulations on campaign finance that fuel the system, that put money in the system and regulate the behavior of our elected officials. So we think very much that this is the keystone issue to reforming the systemic flaws within our democracy. I'd like to offer a couple very specific comments first, some of which will address both the opposition viewpoint as well as those who support these reforms. SB 96 was a legislative approach to the issues that we're discussing within these rules and regulations. SB 96 passed in a bipartisan fashion, the State House. There was broad-based bipartisan support in the state legislature, and it was sent to the governor, and by her prerogative, she vetoed this. I also think that it is the Secretary of State's prerogative to enforce these rules that enjoyed 92% support amongst the public. That's 92 support across every demographic. That's 92% support across all parties, including third parties and unrecognized parties. So I think that SB 96 endeavored to do what the legislature tried to do, and it provided increased access to our system. It provided increased transparency and disclosure to our system. So in reality, I think the Secretary of State's office is in fact going back to what the public wanted in a sense of direct democracy. General comments on on campaign finance. We're at a point of unprecedented visceral rancor in our country right now. We keep having petty ideological debates on a range of issues. Everybody has a number of issues about which they can and should be passionate about. However, these ideological debates will continue to occur until we address what is fueling our public system and our democracy. Until we can make some substantive changes, many of which the rules that you're proposing, Madam Secretary, do, we are going to just continue to shout at each other. So from a general sense, whether you're conservative, whether you're liberal, Republican, Democrat, whatever label you ascribe to yourself, the end of the day, those ideological debates mean nothing until we reform this system to reflect the direct democracy that we grew up thinking we actually had. So I think this is a positive first step. And with these steps that we're taking through these rules and regulations, I have a firm belief that we can then incrementally take broader steps to increase participation and engagement in our political process. Thank you.
Good morning, everyone. Sorry I wasn't here at the beginning to welcome you. My name is Scott Kraling. I'm the Doña County Clerk, but I'm also a voter. Thank you so much first for being here in Las Cruces. I hope that you don't see a small group, very committed, great group, don't get me wrong, and think that this was not a successful attempt. This is just hopefully the first attempt. And the more that we do this, I think the more people that will show up, the more we practice this. We're not used to it. We're not used to state agencies giving us attention. So thank you for doing that, and please come back and do it again. I just want to express that, for me, there's no reason to be afraid of transparency when our goal is to get people to vote. We should do what we can to restore trust in our political process and get people to participate in democracy. So I wholeheartedly appreciate your attempts to shine light on the money that is trying to buy our democracy. Thank you very much.
Mr. Hearing Officer, if I may briefly, I just want to say thank you, Scott, and Deputy Clerk Ellens and your staff for helping facilitate this meeting here today. We really appreciate that and look forward to doing more of these with you in the future as well. Thank you.
Like so many, my name is Mark Wood. I'm a registered voter in Las Cruces. I've lived here since 1967 and voting here since 1967. And I had no intention of speaking before certain comments were made. I've looked through this, and I can understand anybody else who had looked at it who didn't show up, because I find nothing to argue with in it. A comment was made about business owners who fear for their lives, fear for their safety, fear for their children. And I don't see that happening in Las Cruces. I know I have showed up particularly to protest Steve Pierce, and you can't find Steve Pierce. I finally wound up going to a town hall in Ruidoso because he wasn't going to have one here. And I don't think we need to curb people's enthusiasm for the process and put any more limits. And small business owners, if they don't want to appear where we can talk to them, they can hide in their office. We can't go in. And sometimes the only place you can find someone is at home, because it makes it a point not to be where you can find him. But thank you. That's all I had to say.
Is there anyone who hasn't provided testimony who would like to give public comment at this time? Is there anyone further who would like to give public comment? Seeing none, I'll ask if there's any person wishing to submit written comment at this time. Please identify yourself. Seeing none and seeing no more interested persons coming forward to give public comment, I'll ask, has everyone signed the attendance sheet in the back of the room? We will be submitting that as an exhibit into this public record, so please do so if you haven't. I'll hereby admit that attendance sheet into the record as Exhibit 1 of today's hearing. The hearing record is now closed and no further oral testimony will be heard. However, written comment will be accepted by the Secretary of State's office up until today at 5 p.m. After that, all written comment will be submitted into the record for the final record. So if you would still like an opportunity to submit written comments, please do so to the Secretary of State's office by 5 o'clock today. The testimony and written comment in total during this rule hearing and all the other rule hearings will be duly considered by the Office of the Secretary of State. Any rules adopted by the Secretary of State will be filed with the State Records and Archives Center in accordance with the State Rules Act and the New Mexico Register publication deadlines. I would like to thank all members of the public who are present today, and thank you for your participation and attendance. Let the record reflect that this hearing was adjourned at 9:43 a.m. on July 19th, 2017. Thank you very much.